Good afternoon, everyone. Allison Schaberg here, Consolidated Planning Group. We are happy to be here with you today. If you are joining us for the first time, welcome. We're glad you're here. If you've been attending our webinars over the last several years, we're certainly glad that you are back. We are here today with attorney Emily Taylor with Rapp and Kroc, and she's going to be talking to us about estate planning considerations for families with special needs. So we're going to take a deep dive. A lot of the stuff that we talk about, I always preface these meetings, Emily, by saying that there's probably a lot more information that can go into a 1 hour meeting, but we're gonna scratch the surface and kind of get in the weeds as much as we can during the time that we have together. I always like to start with a few housekeeping items. We are in webinar mode today, which means that we can't see you or hear you, in case you are wondering. But our chat box is open today, and so we invite you to put your questions in the chat box. Today's meeting is being recorded. Everybody is going to get a copy of today's slides and a link to the recording, so you don't have to take notes on every single thing that you see on the screen today. If you are joining this and listening to this by podcast and you would like a copy of the slides, you can email us at contact@cpgcares.net, and we'll be happy to send you a copy of the slides for today's presentation. If you sent in a question ahead of time, we do have those questions, so it is not necessary to put those questions in the chat box. So we are going to be getting to as many questions as we can during the time that we have together. So just for those of you that are joining for the first time, Consolidated Planning Group is a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy, chartered special needs consultants. We're also nationally certified as Social Security advisors. Our whole firm is nuanced in helping you plan for the future of the loved one with a disability. But I always like to make it clear, we don't do what Emily does. We're the money, she's the paper, the legal documents, the things that have to be in place. People come to us because they want to know how and what they should be applying for. How do they preserve eligibility for state and federally funded programs? When should they apply? What should they apply for? How much money do they need to fund a special needs trust? We help people set those things up. We help with lifetime care plans, protection plans. We do a lot of transition planning. We help establish ABLE accounts, and we do a lot of advocacy by way of webinar. And so when it comes to planning, we always suggest that you work with a specialist. Whether you work with us or you work with Emily, work with a specialist that's specifically nuanced regarding individuals with disabilities, because our situation is specialized and you want to work with a specialist that gets it right. When we don't have money in the right buckets, you can lose eligibility for state and federally funded programs, and it can be problematic. So having said that, Emily, welcome. We are so glad to be here with you today, and I'm going to let you take it away. Thanks for being here.
Thank you, Allison. Yeah, thank you for having me. So, as Allison mentioned, she is the money, and that's important. There are not a lot of her. There are not a lot of folks that are doing what she's doing. And if they are doing it well, it's not just, benefit planning, which we'll get into a lot of the things where we kind of overlap, where we want to communicate, but it's also making sure that the assets that you have are going to go where they belong and provide the right kind of income for the right plan, right? So, you don't want me to talk to you about compounding interest and that kind of thing. I'm a lawyer, so that I don't have to do the math. But what is that? What is that I can do then? So I typically hold myself out as an elder law attorney. What that means is that fundamentally I'm an estate planning attorney. I do probate work, I do guardianship work, and I have a focus on long-term care and special needs. And so, what people don't appreciate is that the elder law community and the special needs community, they overlap a lot. And the reason they overlap, the broader special needs community encapsulates the elder law community in my world a lot, because a lot of the programs, a lot of the rules, they are the same for a special needs community and an elder law community. They're both populations of folks that have a lot of safeguards around them that are similar. And that's why most elder law attorneys, not all of them, but elder law attorneys you talk to are talking about typically planning for the special needs community at large. Rapp and Kroc is a mid-sized law firm in the Galleria area in Houston. We fundamentally, we're a business transactional firm. That's how we were founded. There's been someone like me here since about 2008. I have been at my firm for nearly 7 years, and prior to that, I worked at a boutique elder law firm where that is all that we did. So the benefit here is that we can do the business transactional work. We've even launched a business for a child with special needs who had put together a business where she was selling items that she created. And so we put together a business for her. We talked through whether guardianship was the right thing for her. Ultimately, we decided that it was not, and that her incapacity didn't rise to the need of guardianship, which we'll get into in a little bit. And now here she is with her own small business. And that's the kind of thing that's sort of unique to our firm, that we can kind of represent holistically the family, the planning for the special needs person, and whatever that looks like, right? Whatever their dreams might be, if we can help navigate that, we will. So the unique challenges here that we have in this area of the law is the attorney-client relationship. So it's, not unusual that I'm dealing with somebody who is not the person I'm planning for, right? So maybe I'm planning for a spouse with some kind of an injury, or a mom or a dad upon a diagnosis. Often we're planning for children. Sometimes we're planning for children who are not minors and they have a diagnosis or an injury, and we're navigating whatever that looks like. But it's not unusual for me to not be regularly in communication with the person who we're planning for. And that's tricky because attorney-client privilege is important, right? I made it my second bullet point because it's important. And that's obviously going to be more important if we're ever fighting about it down the road, fighting about the decision that was made, the plan that we put in place. In a world where everyone's amicable, we're usually rowing in the same direction. Mom or dad or spouse planning for the child, or, whoever it is that has some kind of a special need. The people that come to see me are usually coming to help them. So we're typically aligned, right? But we want to think about a world where we have somebody that has special needs that has more autonomy than that and more independence than that. And we help those folks too. Okay, so I have a couple of clients right now that we're kind of part of their team, right? So I'm thinking somebody who might have an intellectual disability, but they are really very high functioning. They're really very independent. We help those people too. We put, documents in place that we'll talk about here in a minute to help them kind of navigate the world. We sometimes are putting documents in place for folks who maybe are typically pretty independent, but they might have some kind of a behavioral or mental health situation that gives them opportunity to need more help whenever they have some kind of an event or a crisis, or whatever that manic thing might be. And so we can put documents in place for those folks too. And in the meantime, they're my client. I'm talking to them relatively regularly, or we've put in place the people who we want to be able to make decisions for them when they're having some kind of an event, or addressing what those details might be. So this is unique, right? Because it's sometimes that I can help the person with a special need, and it's sometimes that I need to help the people around them help them, right? So that's just kind of an unusual challenge to this area of the law. I would say, and you'll see this as a theme, I think, across the entire thing, is we want to think holistically, and we want to put a team together for these folks, right? So people like Allison, people like me, often there's a CPA involved, often there's a care manager involved. There may be caregivers involved, just depending on the nature of the disability. There's all kinds of people you can put in place depending on the circumstances. A trustee, an individual trustee, a corporate trustee, we'll get into those too. But the folks that we need to put in place to make sure that these people with special needs are taken care of by kind of from every perspective in every direction, right? So sometimes I'm just part of that team that's kind of keeping tabs on whoever this person is and whatever they might need. And I'm here to answer the legal questions while we go to Allison, or we go to the CPA, or we go to the care manager for the boots on the ground stuff and things like that. So what does it mean? What does special needs planning mean for me? For my practice, special needs planning, well, let me say it this way. Folks will say that they do special needs work, or that they do elder law work, or that they do, disability work, and it can mean a lot of things. And so I've listed them here because this is defined by a population of people, like I've mentioned, right? Rather than an area of law. So it's not like I'm going to go to the tax code and it's the only thing I need because I'm a tax lawyer. Or I'm going to go to the property code because I'm just doing real estate work. These are people. It's defined by people, and lots of different areas of the law touch people, right? So disability planning is part of what I do. Certainly the directives, the trust, and the estate planning is a huge part of what I do. The guardianship work, the long-term care planning, there are certain means tested benefits that I'll get into in a minute that I work on. There are lots that I do not work on. Social Security, right? There's that's obviously a federal program. I don't do those applications, but it comes in and out of my world a lot. So I can speak relatively intelligently to those. Medicare work. I'm not a Medicare broker. I don't sell health insurance, but this is a big piece for folks who are looking for health insurance, whether they're over 65 or they're on SSDI or they receive Medicare through another Social Security program. There's lots of things that people need help with Medicare, appealing for when they get coverage denied, things like that. That's what some people need or are talking about when they talk about special needs planning. Housing, I've done a little bit of HUD housing work in my time. I don't do it every day, but some lawyers like me will spend time trying to help folks with their housing needs. Exploitation and neglect, of course. I get a lot of these phone calls. Most of them are not cases that I handle, but obviously this is a vulnerable population. Because it's a vulnerable population, sometimes they're more likely to be exploited and neglected. So those are calls that we get. It could be a fall, it could be financial abuse, all kinds of, just things that vulnerable people are subjected to. We'll get calls like that. And we don't handle those, but there are other special needs attorneys or elder law attorneys, or even sometimes, depending on what we're talking about, education attorneys that can help in those scenarios. Assisted living and skilled nursing facility rights are the last one on the list. Sometimes we're working on this. And so what this looks like is that there's a Bill of Rights. There's a Bill of Rights whenever somebody is a ward that has a guardian over them. There's a Bill of Rights for people that live in assisted living. There's a Bill of Rights for people that live in skilled nursing facilities. If those rights are being abused, if those rights are being ignored, whatever that looks like, we are sometimes helping folks with that by writing a letter to the person that has violated whatever those rights are. If it gets more contested than that, my office is usually not handling it, but there are lawyers that hold themselves out to be lawyers like me, and they're doing rights work all the time. So that's what planning looks like holistically, generally in this space. We'll talk about the stuff that I can really help you with and that pertains to most of the questions we've already received for just a second. So government and Medicaid benefits. This is where I've spent a lot of my career. And this is what we're often talking about. So when we're talking about government benefits, when we're talking about long-term care planning, as Allison can speak to probably better than I can, we're often talking about how we're going to afford it, what the money looks like. It's not cheap to take care of somebody for their entire lives, especially if they have low or no earning potential. So what does this mean? There's opportunities out there to get some money in their pocket, right outside of your typical earned income. And even sometimes outside, there's various programs that we can kind of mix and match depending on what that looks like. There are over 100 Medicaid programs in the state of Texas. I'm only licensed in Texas, so I can only speak to Texas. But there are over 100 Medicaid programs in the state of Texas. I typically work on about 4 of them that are all for folks who are adults who are in need of long-term care. That's typically what I'm looking at. There are lots of kids programs that I'm familiar with but don't do the applications for. So what I help people do is get on the waiting list, which I'll talk about a little bit more in a moment, but get on the waiting list for these programs. Some of the waiting lists are, up to 16 years long for a lot of these programs for kids. So I often, when I'm working through, it's usually a guardianship case. If that parent has never been talked to about the available programs in the state of Texas, I talk to them about those. I encourage them to get on the waiting list. And then when they're ready to apply, then I'm not their person. But there are other lawyers like me who do handle those programs. They help with things like housing, group homes, therapies, all kinds of, and Allison's very familiar with these programs too, but all kinds of stuff, day programs, all kinds of things to help folks who are ultimately eventually going to need help and their parent won't be there forever. And a lot of these programs are tailored to that kind of thing. Those programs, both the ones I work on and the ones I mentioned to you about children that I don't, income is a huge piece. Okay, so these are almost exclusively means tested government benefits. And what that means is when you ask to get the benefits from the state or from the feds, if it's a Social Security program, they're going to look at your money. They're going to look at how much money is in your pocket. They're going to look at how much money are you getting recurring monthly. That's your income. And income is a really big piece. And so to really give you the nuance without getting too far into the weeds, when we're talking about an adult looking for benefits, we're going to worry about the adult's income. When we're talking about a child receiving benefits, if that child has income, I suppose we're concerned with it, but we can also deem some of the parents' income to the child. And so it's not like, well, my kid has no money, and so they're going to be eligible. The parents' income is relevant to some of these analysis. So income is really important. And so if you'll go back for me, what I want you to hear about income is most of the people I'm dealing with, they're getting money from Social Security or the VA. There are lots of Social Security programs, okay? There's programs, what we're all pretty familiar with, I would call RSDI. That's whenever we reach retirement age, we get retirement money. If we paid into the system, we're going to get some percentage of that back based on the formula that the Social Security Administration has for you and or your family, depending on what your family unit looks like, okay? That's what we all kind of think about, right? There's Social Security disability insurance, and that is when we would otherwise be working. We have a work history, and we are now not able to work, maybe for a disability or a diagnosis, and we're asking the government for money, and they can see that if you could, you would work, but because of your disability, you're no longer working. That program also comes with Medicare after 2 years. And so that is important for folks, right? To worry about their health insurance if they're no longer working. That program is most worried about just your income. Again, right? Income's a big thing. And why? Because they're going to give you income in your pocket. There's also programs for disabled adult children. There's programs even for folks who maybe are divorced from a spouse and they could have received Social Security. So there's lots of ways to get Social Security income. The other common way for folks in this community to get income from Social Security is going to be supplemental security income, and that's SSI. And that is the program that says, I'm going to get some money in my pocket because I cannot earn my own money due to my disability as found by the Social Security Administration. So there's a limit to that, right? And right now, that number, I don't know what it is for 2026, somewhere in the $960 range, probably.
It's 967 for 2025 and 994
Here we go.
for 2026. And I also just wanted to mention too, Emily, that there is a such thing as a child in care program too. So where like one parent is drawing Social Security, the other parent might be younger and waiting to turn theirs on. That parent could get a child in care benefit under the other spouse's record, and the child could get childhood disability benefits. And that is one benefit that most people don't even know exist. And in our experience, nobody ever enlightens you at the local office about.
Right.
It's one of those things that you kind of have to know about it. And I also just wanted to mention too, Emily, we do a government benefits 101 presentation, and we try to do that presentation actually every month because inquiring minds want to know. It's so much information and it's kind of information overload. But that lives on the Consolidated Planning Group YouTube channel. So if you miss that and you want to go back and you want to take a deep dive into government benefits, we've done many presentations on that. We've done how does working affect SSI versus working and affecting SSDI. But one thing I think that happens all the time, and I know you see this too, is these are very different programs. although they sound the same, they are not the same program. So they're little acronyms that they throw around. It becomes very confusing for people. So educating yourself and learning about the entitlement programs as opposed to paying in and earning on a Social Security record is two different ball games. And I just want to make that clear because I think there's a lot of confusion with that.
Yeah, thank you, Allison. Right. So there's lots of programs, and how the income is deemed to the person or not is going to vary depending on the program. And then kind of the next point I wanted to make was some have an income only test, which is on the heels of what Allison is saying. The tests are different, the income is different, the cap on how much income you can get is different. But supplemental security income, SSI, where we were, that's going to get you just shy of $1,000 a month. But in Texas, even $1 of supplemental security income also gets you Medicaid as your health insurance. And again, a lot of these people have big medical needs or medication that's very expensive. And so the opportunity for somebody, even if they're not going to pocket all 990 some odd dollars that's going to be potentially available under SSI, even if for various reasons that we won't get into here, that amount is reduced to $600 or whatever that looks like, getting the Medicaid as the health insurance along with SSI is often the driving force for folks applying for some of these Social Security benefits. And then most of the programs that I work on have three prongs of eligibility. That's medical necessity, income, and assets. And a lot of these children's programs run by the state of Texas have similar three prongs of eligibility. So we're looking at what your medical need is. In the elderly population, that's often talking about your ADLs. There's like a term of art being medically fragile that we see in the children's programs that is a different analysis. But your medical necessity is one piece, your income is another piece, and then your assets are another piece. And the reason these are all very important is because this is often what we're planning around when we talk about estate planning for your folks with special needs. We're putting things in trust to play with or navigate or finagle the rules for your income or your assets, right? Go ahead, Allison.
I just wanted to mention, I think of the money side of it, and people think, okay, 994 a month starting in January 26th, and I'm going to apply and it's going to get approved right away. I like to let people know that they should fully expect in Texas, other states are differently, we're behind, that these applications and processing times are well over a year. So if you apply, you need not think that you're going to have money in your account anytime soon. It's a very long process. They're understaffed and they have way too many applications. So I just want to set expectations clearly. But there are such things as fast-tracked applications when there is a presumptive condition where they presume that the individual is disabled. More severe cases, a person that cannot do any of their ADLs might qualify for presumptive. Down syndrome is presumptive. There are more than 200 presumptive conditions. So you want to type in that word to Google presumptive conditions, look up the list and look up your loved one's diagnosis to see if they have a presumptive condition that there is a compassionate allowance for, where they will fast track that application. And if that is the case, you want to make clear to the representative, whether it's on the phone or in person, that you understand that your loved one has a presumptive condition that there's a compassionate allowance for, and that this application will be fast tracked. And I would mention that multiple times.
And Allison, wouldn't you agree though that most of these programs, I tell people to expect 18 months when we're talking about Social Security, but
I
in
think it's a
addition to
minimum, a very, very minimum of about a year, year and a half. And I
it's been
think that
pretty
that's
slow.
reasonable. And I would say that one of my kids was denied 3 times and approved at the administrative law judge level. And that was 3.5 years later.
Right.
And they were approved, retroactive, should have been approved from the beginning, but that's how long it took. And so I'm not trying to be a Debbie Downer here, but it is the reality of the situation. We're hopeful that it will improve, but it hasn't. So
And they'll get the back pay is where I wanted you to go,
yeah,
was
yeah.
they'll get the lump sum back pay typically after they get approved down the road. And that's something we have to think about and have a plan for, because now there's a chunk of cash that could turn around and be, have some kind of a negative effect on the benefits program if we have that in our bank account, right? So anyway, yeah, so there's a look back and a transfer period, and that's important too when we talk about estate planning for folks with special needs. If they're preparing for government benefits, it depends on the program. Again, some have no look back period, and what this means is the agency that's looking to give you benefits, they can go back. They can say, I need you to give me 1, 2, 3, 5 years of bank statements so we can make sure you didn't give anything away that you otherwise could have spent on your care, right? Some programs, the VA has got a 3-year look back. I'm not accredited with the VA anymore, so feel free to take everything I say with a grain of salt, but I did spend a lot of time doing that work once upon a time. But most of the programs I'm looking at have a 5-year look back period. A lot of the programs have a 5-year look back period, and we can plan around that and when the circumstances present themselves. So the last thing I would just mention that I think people miss when they're talking about benefits programs is there's an ongoing recertification. And what I mean by that is just because you got the benefits does not mean they let you right off into the sunset. They're going to come back and check. Most programs annually are going to come back and check and say, do you still need this? Give me the balance of your bank account. How does your medical necessity look today, right, when we're going forward? So it's not a set it and forget it thing. If you're, for example, the representative payee with Social Security, you're accountable to Social Security. If you're on another benefits program, you're accountable to that agency. We'll get into if you're the guardian for someone, you're accountable to the court. So all of these things are an ongoing kind of becomes part of your life as you go forward caring for this person with special needs. I said that would be brief. It probably wasn't that brief. You can go on to the next slide, please. So here's probably what you came for, right? So the estate planning piece. If you'll back up for me, almost. There we go. So this is what kind of the bread and butter of my practice looks like. We're talking about advanced directives, trust work, estate planning, and guardianship. And in the context of special needs, here's often what that looks like. I colloquially call them advanced directives. That is an actual term of art in the health and safety code in Texas. I'm not referring to it that way, but people will kind of add and subtract different documents from the term advanced directives. What I mean here is the ones I've listed here. So let me kind of decode what these stand for. The medical power of attorney is first. This is your medical power of attorney. To be able to sign these documents here on this first line, generally, we need capacity. Okay, and so not all of the folks we're talking about are going to have the mental capacity to understand the consequences of these documents. And we'll talk about what you do if you don't have that here in a minute. But your medical power of attorney is the one that, best case, if we have capacity, we want somebody to be able to sign. It says who can make my medical decisions when and if I can't. And you can pick whoever you want. If you do not name someone in a medical power of attorney to be able to make your medical decisions, then there is a pecking order set out by the law. That may or may not be who you want that to be, okay? So there's emergency folks that you would put in line, and generally it's going to be like parents or spouses if there's a spouse, parents, adult children, that kind of thing. This too varies by state. I don't know exactly what our audience looks like, but this can look really different state to state what the pecking order would be if we didn't have the document, but that's who makes your medical decisions. Your SDPOA is your statutory durable power of attorney. This is who handles your finances, right? This is who handles your contractual obligations. So it could be as simple as we are getting into someone's bank account to, pay the water bill while we are having an operation, or because I've declined dramatically with my dementia or whatever. It could be as big as filing your tax return or signing your lease at your apartment, or, whatever your contractual obligations are. Your medical power of attorney and your statutory durable power of attorney, both are documents that are provided for in the code. So of course, I always encourage people to go to a lawyer and get the right thing put together, but they're also something that you can go find somewhere. I don't encourage that, but I do want you to hear that these are something that exists in the law and they're real and they're accessible to everybody. Importantly though, They're so nuanced, especially that statutory durable power of attorney, because there are lots of special powers to turn on and to turn off. Okay. The next one is going to be your HIPAA authorization. This is just who can talk to your doctors. We've all seen HIPAA. It's federal legislation. It says, if you want to call for my medical record, you can, yes, release it to my husband or whatever, right? This is like a master form. So no matter where we are, we can go get records from the other institution, or we're in an emergency room and we didn't ever get the chance to sign it there. This tells us who can get that information. This document also survives the person who signed it. So let's say that we have lost somebody and we're now arguing about a medical bill, or I mean, I've had all kinds of things with this document. We've autopsies and all kinds of things. This document survives by 2 years. So the other ones, they die with you, right? You can't have agency for someone who's not here anymore, but your HIPAA remains. Your living will is a document that says, if I have a terminal or an irreversible condition and I can't communicate with you and I need life-sustaining treatment, then either give me the life-sustaining treatment or don't give me the life-sustaining treatment. It's really, really, really narrow in scope, okay? It is, you have to be able to, you have to need life-sustaining treatment. People walk around every day with terminal conditions or irreversible conditions and they can talk to us. Or they don't need a ventilator, right? But if all those things are true, you have a terminal or an irreversible condition and you can't communicate, and you need life-sustaining treatment, then this document will come into play and you will have made a decision on the document whether you do or don't want life-sustaining treatment. This one gets really interesting in the special needs community, in my opinion, because I've had various folks who, like, for example, will live forever with a peg tube or whatever the thing is, right? And so they will say, well, hold on a minute, this is how I survive now. And so we have to tailor this document in the special needs world sometimes for what we know is coming. You're on dialysis. Well, dialysis is considered under this document life-sustaining treatment. And so we want to write that out. We want to make sure we get dialysis. We know we're going to have dialysis forever. That's part of our condition. So we don't want that to be the thing that gets withheld. So this document, again, available publicly, although I encourage you to get advice when you're signing any of these documents, but this one can also be one that people can unknowingly, in the special needs community particularly, kind of sign away something that's a lot more important than they realize, or that's included in a definition that they weren't paying attention to, right? The Declaration of Guardian is the one that gets really important. This is kind of addressed in one of the questions that we got ahead of time, but that's what the DOG stands for, the Declaration of Guardian. This is you telling somebody who you want to be your guardian if you need one, or in a lot of circumstances, me, for example, telling you who I want to be the guardian for my children, right? And this is the same for somebody who's serving as guardian for their adult child with an incapacity. They can say, if I weren't around, now that person still has to qualify to be a guardian and all that good stuff, but if I'm the guardian for my child and I'm not around anymore, here's who I want to come up next. Very importantly, for a lot of people, we can also veto folks in this document. We can say, here's who I would want to be the guardian for my child going forward. They're the ones that know that, at this time on Tuesdays, this is what she needs, or whatever the thing is, right? And so that's by name. They don't have to be related or any of those things. It's the people you want to be your guardian. You can also say, here's who I would never want to be the guardian. Lots of families with special needs have folks around them who maybe we expressly don't want involved, right? And there is a pecking order for a guardian. So if that person is estranged from the family or has a substance issue or is opportunistic and would come forward and try to take our loved one with special needs if we weren't here anymore, we really want to give the opportunity to tell the court, if we're not here, please don't let this person come forward. And so this is often a really important document. Go ahead, Allison. You're on mute.
I just wanted to mention that on this, the power of attorney, the healthcare power of attorney, the HIPAA release, these kind of documents, I know that we're always thinking about our loved one with a disability. And I would just like to remind people to think about this, to have intentional conversations with your aging parents. We see that aging parents either don't have any documents, or maybe their documents haven't been looked at in 15 or 20 years, a really, really long time. And we strongly suggest that you get these, power of attorney, healthcare power of attorney, HIPAA release for your adult neurotypical kids that you're sending off to college, we think it's a really good idea to have those documents. But I just want to convey the importance of having your documents. I'm not saying you got to go redo them every 3 to 5 years, but revisiting them every 3 to 5 years is good. Things change, people die, people's capacity changes. And so what might have been good for you 5 years ago might not be at all what you're thinking right now. So do look at this, but just a reminder for the aging loved ones in your life, have intentional conversations with them on this. We had a client a few years ago whose mother passed away, and her documents had not been updated in more than 20 years. And there were more successors in her documents than I had ever seen. There were 10. I'd never seen that many. And the crazy thing was, because those documents hadn't been looked at in all those years and mom died suddenly, all 10 of them were deceased except for the 10th one, who was 99 years old and had dementia. So anyway, it was kind of a mess, to say the least. So you can prevent that by looking at them from time to time.
Yeah, thank you. I agree with that statement. Checking on them. I mean, there are folks that I will see in close succession where something has changed. Someone gets divorced. That's someone I see in the Declaration of Guardian a lot. Is someone will say to me, well, that felt like the right idea, but now that they're single, or, now they have 5 kids and maybe they couldn't also take on my kid, that kind of thing changes a lot. But they are important. And then you want to think about who is it, and the kind of backtracking on that comment, Allison, is the financial power of attorney, the statutory durable power of attorney. One of the things that we always address really specifically in our office, that you have to address specifically in a financial power of attorney, is whether gifting matters. Okay. And I don't mean, can you buy a Christmas present, although that would matter whenever we're talking about the gifting authority under a financial power of attorney. But in a lot of these scenarios, I mean, I can think of 2 or 3 right off the top of my head that I have right now. And these families have folks who have special needs who will probably never pursue government benefits. They have lots and lots and lots and lots of funds, right? But that said, it's like mom taking care of, making sure that son with special needs, who's an adult, that has not been determined, adjudicated, incapacitated by law, because he's got enough independence to live on his own. She is paying his rent, right? So she pays his rent. Well, if she is incapacitated, does her agent have the authority that's a gift, to make that gift to that child? Because in the eyes of the law, he's a child with no disability. He's just an adult kid that she's making gifts to, right? You have to identify gifting in your financial power of attorney. So if you're taking care of someone and you're not here tomorrow, or you're here but you're not with us, then what, right? And so that's the kind of thing that can be addressed, that does have an impact on your loved ones with special needs. I see the same thing the other direction, like we're taking care of mom. She can't, she's only on Social Security and she can't afford her X, Y, Z. Well, if something happens to you, who's going to keep that up for mom? We can address that in your will. We can address it in your financial power of attorney. But those are big pieces that people miss sometimes, right? That are just circumstantial to your family. The PAD is where we stopped. And so this is the psychiatric advance directive. This one's really specific. I don't do mental health work, although it kind of comes in and out around me a lot because of the nature of the work I do. And what I mean by that is, this is an advance directive and it lives for 3 years, I believe it is. We can fact check me on that, but I believe it's 3 years at a time. And this is for our loved ones who have like behavioral or mental health incapacities, right? And maybe they spend a lot of their time fine, but if we have an episode, or if we're off of our medicine, or if whatever the thing is that triggers whatever happens, we can address, the person that has the mental health issue can address either, here's what works for me. I need isolation, or I don't need isolation, or I need restraint, or I don't need restraint, or I prefer a male doctor, I prefer a female doctor. You can put all these kinds of things in place. You put it on paper, you tell them what is the best way to help you whenever you're having some kind of a manic episode, because when we're in mania, we're not making decisions that are terribly clear. Those same people that may be having some kind of a psychotic episode, right? They should also have medical powers of attorney, HIPAAs, these kinds of things. Because what happens a lot of times in these scenarios, if you're a family that has this as a piece of your puzzle, is when you're on some kind of a hold, no one can communicate with anybody unless you authorize them at that time. And at that time, you might not be in a position to be able to make that kind of decision. Your HIPAA is not going to get you all the way there, but it's going to get you closer than if your loved one with a psychiatric issue has no documents in place, right? That path
I've
has to
seen
be
a
revisited.
mental health thing, like a legal document, a mental health one where like they
Mhm.
basically sign that they're authorizing like during like they're of sound mind and body and that they're authorizing in times of
Mhm.
confusion or psychosis or whatever that they authorize you as their representative or whatever. I've seen some documents like that.
Right. Yeah. Authorizing someone as your representative, you're going to just have to hope that that hospital believes in that. They really, what they should be doing is making decisions while they're alive, right? According to the directives that you typically see that kind of oh gosh, I can't think of what the board is called that kind of authorizes these, but they're typically saying, here's what I want. Yeah, I usually include like, here's who you can talk to, but your HIPAA should do that for you too, right? And then it's usually about restraints, medications that should or should not be mixed or whatever. And then I mean, sometimes it's the soft stuff, like music helps, this isolation helps, it's that kind of thing. But these expire after 3 years unless you're in um unless they're being used, they expire at 3 years, right? And so then you have to revisit it again. Again, fact check me on that timeline, but I think it's 3 years under the code. So these are valuable. People miss this opportunity a lot. And it's just like meeting with somebody that's asking their real questions and the hard questions about the people in your life and your family. But these become important. And more often than not, I get the phone call that's like, my son was picked up. I can't talk to anybody. What do I do? And I say, did he have any documents? Do you have any authority? And so, to your point, Allison, about the 18-year-old going off to college, I mean, you're like in prime age range for kind of learning about somebody's different mental health deals that we may not have known when they were 13, right? And so if you have at least some authority, we can sometimes get you in, get you some information. But otherwise, I have to say to them, I'm sorry, this is really hard. Here's who you should call. And then whenever he's back, let's get him in here to make sure we have documents ready for the next time.
Yeah, we saw a lot of this with COVID and college kids getting hauled off to mental health facilities with no documents in place, and they won't even tell you where they hauled your kid to.
Right.
You won't even know where they are. It's like a needle in the haystack. So it's for real. We have a few things in the chat box and just about 18 minutes left for today. One person wants to know the generalized expenses, and I know you can't speak for all attorneys on, setting up estate planning documents, and can you pay for this out of an ABLE account? You can pay for legal services out of an ABLE account. That is achieving a better life for an individual with the disability. Financial planning, legal planning are all things that can be covered from an ABLE account. But can you give us just a range on this
Sure.
kind of thing?
Yeah, it certainly depends on whether we're talking about a single person or a couple. Everybody that comes through, if we're talking about let me say this, what I don't have on here, which is shame on me, is a supported decision-making agreement. If we're talking about the person that has a disability, then I would encourage, depending on their level of capacity, the things you see on the first line, right, that are relevant, who they want to be their guardian, if they were unable, if they actually rose to the need for a guardian, right? Your living will, your HIPAA, all of those things, and a supported decision-making agreement if that's appropriate. A supported decision-making agreement I should share is kind of in the gray space between you have no capacity and you have total capacity to be able to understand the implications of all of these documents, your financial power of attorney, your medical power of attorney. Each of those documents, the person signing it has to understand the consequences of it to be able to have the actual capacity to sign it. It is not unusual for me to have someone come in and they have some kind of intellectual disability and they can understand who do you want to make your medical decisions, but they cannot understand a financial power of attorney, and what do you mean file my taxes, and who would handle my business, so it's not unusual for me to get somebody that could sign a medical power of attorney but couldn't understand the consequences of a financial power of attorney. What they can do is they can do a supported decision-making agreement, which says, I get it to a point, and I've always relied on my sister. And my sister can talk to the bank and help me understand in my way what question you're asking or what you need from me. And she can help communicate with the bank for me and help me make a decision. She's not taking power away from me, but I'm authorizing her to the extent I can to help me, right? It doesn't rise to the level of financial power of attorney, but it's kind of as close as we can get. So I rambled for a moment, but folks like that are coming in, they might have some stuff that we need to do a will for. Whether they have a capacity for a will is another question, a different standard. But if they did a will, a financial power of attorney, a medical power of attorney, and a supported decision-making agreement, they'd be walking out of my office somewhere between $1,000 and $2,500, probably, just depending on the complexity. Individual people with all 5 of those documents and a special needs trust and another, we have a set of all of these documents and we include the special needs trust within the will, it's going to be somewhere in the higher end of that range. If we have 2 people, a husband and wife or whatever, it's going to be not quite twice that. But that's like a good rough idea. I'd say you
And
can find.
I feel like a good range is like 3,500 to 5 grand for a couple for all things. Like,
Right. And when we're talking about the couple, if we're talking about the person, it's going to be a lot lower than that because they're not going to have that many documents
sure.
types. Right. But if we're talking about a couple with all the things, I think you could say about somewhere in the 2,500 to, $5,000 range, right? Because we're going to say not quite twice what it would usually take an individual, but somewhere like that. So that's fair. It depends. There's so many things to consider when we talk about cost. My office, if you have special needs work, we're typically doing it hourly. And so my group at this office is between 450 and down. So I'm the most expensive person you deal with in my group in my office. Everybody else is cheaper than that, and we bill hourly. That said, the reason we do it that way is because, especially in the special needs world, we've got a lot of nuanced questions, right? We want to make sure we address all of the needs. And sometimes we're including things that aren't on here, like letters of intention. Sometimes we're including like caregiving instructions and things like that. So those things just kind of obviously add to the cost. But I really want to speak to trust before we get too deep. Is that okay
Yes,
with you?
I just want to just go over a couple of questions so we can move to the trust. One person said, "What happens to Social Security if I pass and I'm not married? Can my daughter receive the benefits?" So if you have a disabled adult child's disability began prior to age 22, then they would be eligible for 75% of your benefit. It's a survivor benefit. So that's basically what happens there. One question, there was a person in the chat box that said their kid is 11. How early should they start? And I think the sooner the better. Now you don't need guardianship. You are the guardian prior to age 18, but getting your estate planning documents in place, and I used the term like yesterday, we don't know when we're going to die or become incapacitated. It is important to get our legal documents set up and then revisit them from time to time. And from a financial perspective of planning, the earlier you start, the more likely you're going to reach your goals to be able to fund a special needs trust and be able to retire and stay retired. So we encourage people to get started or pick up where they left off on that. And then one other thing before you go into the special needs trust, there was a person that says, when do we create a special needs trust and how do family members designate that as the beneficiary? And that is an important conversation because a lot of people in my world that we work with, they think that once they work with someone like you as an attorney and they set up their legal documents, that everything's signed, sealed, and delivered, which it is there. But beneficiaries trump. They think that their legal documents just made everything the beneficiary of whatever spelled out in the legal documents. And so beneficiary designations and getting that right and revisiting those from time to time are important. So I'm in the essence of time, I'm going to just have you move on to special needs trust and you can address that. So thank you.
Yeah, thanks, Allison. So I just want to make one other comment. The person that asked about Social Security and if it would survive you, there are if you're one of these people that's receiving like OPM, civil service, or TRS, those also, if you have an adult child with a disability and you make the right election when you retire, those also have some funds that can carry on for your adult child with a disability, if you make those elections. So it's not just Social Security that has that benefit. And
I just want to mention too, though, it is important to have those set up properly to go properly to like a first party special needs trust. Like I think of like the military pensions, like the National Defense Act of 2015 changed it to where military pensions could be left to a first party special needs trust. Previously, they couldn't. And so finding out, can it be left to a first party special needs trust? If it can't, what provisions are available, and working with proper legal folks to do that, because when we leave it to the named individual, it's a problem. So
right,
I just
right.
want to mention
And
that.
the beneficiary designation is a big piece of that, which is here on this slide and which Allison mentioned. And we see that in planning with people that aren't even planning for special needs. But what it means is just because you put your document in place, your trust, your will, whatever it is, you still have to go back. The part of the game, part of the process is knowing what your stuff is and making sure that the beneficiary designation or the style of the account or the POD designate, the pay on death designation, right? Whatever that looks like has to be accurate, because I have a great example of a case right now where they thought they did everything right, and she put a will together and her will said, I have a child with special needs, here's her special needs trust. What she didn't do is any of the other stuff. So ultimately she died and her money went directly to her daughter with special needs. Her pension went directly to her daughter with special needs. And now we have a guardianship that could have otherwise been avoided, right, if these beneficiary designations had paid through the will to the special needs trust. And then the other thing I wanted to mention on that question is, how do you tell people? So you can create a special needs trust within your will that doesn't exist yet, right? I'm alive, I have my money, I'm going to pay for the thing as it happens for my kids or whatever. If I'm incapacitated, I have a financial power of attorney that authorizes somebody as my agent to keep paying for my kid if I'm incapacitated. And then when I ultimately die, all or some or whatever of my stuff is going to go into a special needs trust for my kid. That works. That would come out of your will, and assuming that all of your assets actually flowed through your will, it would fund that special needs trust. Now, what a lot of folks will do, especially if they know we have other family members who want to contribute to our child with a disability, then we would create a special needs trust today. And this is what we call an inter vivo special needs trust, because lawyers like to talk to you in Latin. I don't know why. So the inter vivo special needs trust means I created it during my lifetime, and I'm going to put something in it, presumably today. Okay. And you don't have to fund it with everything you ever want to fund it with. You could give it a little something today, and then you can tell all these people that you know want to provide for your loved one, here's the name and the tax ID number for the trust for my child. You can name this trust in your will, and that's where their share will go. Okay. My suggestion to people is, if you're going to create an inter vivos, a lifetime special needs trust for your person now, that you tell everybody that might want to know. Right. That way they don't double dip and do this over here, or, do it wrong. And I see that all the time too. That aunt or uncle or whatever has good intentions, and they name your child on their life insurance policy, and then they die. And now your child with special needs is inheriting a life insurance policy that they can't manage. And it's just expensive to collect it and dump it where it needs to go. Some wills can be reformed. We do that kind of work around here whenever it's like, we can prove that it wouldn't have been contrary to uncle's intent to make sure that the piece he was going to give to his niece with the special needs is held in a special needs trust instead of given to her directly. We can reform a will if there is a will in a lot of cases, but we can't fix a beneficiary designation. So if a beneficiary designation goes to the wrong place, you're stuck asking the court to let you collect it on their behalf. And that can look a lot of different ways. So when we're talking about trust, there's a million different kinds of trusts, and there's a lot of the same trusts with different names and things like that are confusing. But for the purposes of the next 5 or 6 minutes that we have, I want you to hear that what you're usually talking about in this space is a special needs trust. And there are different kinds of special needs trusts, but the one that I would typically want you to think about and promote is called what I would call a discretionary special needs trust. And what it means is it would be a special needs trust that's set up in a way that says, my beneficiary, my person who's receiving presumably one day government benefits, or isn't going to be able to manage their assets, right? They're going to receive in this special needs trust. They can never be their own trustee. They're never going to be the one in charge of saying, I need this money for this health event or this vacation or whatever the thing is, right? We will need to name a trustee. So when you're talking about trust planning, the thing to think about is, who do I trust to manage this money on behalf of my child? While I'm around, it's probably me. Right? If we trust no one, we can go find a corporate fiduciary, a bank, a trust company that would be willing to stand in those shoes and make those distributions. Now, any trustee that you choose should do the right thing and go get counsel. Talk to an Allison, talk to me, talk to a CPA, make sure they're making all the right decisions, right? So they don't mess anything up. But they would be a trustee, managing the money, making sure Allison invests it the way it's supposed to be invested, making the distributions as they need to. And if it's a special needs trust that you set up or somebody set up for your child, it was not money that ever belonged to your child, then that's what we call a third party special needs trust. And that means that ultimately, when your child is gone, if there's any money left in that trust, you get to decide where it goes. Okay? It's very different than a first party special needs trust, which means first party, me, the child, that's money that I was entitled to. That's money that came to me in my name. Okay. Now I can go put that, if I'm under the right age, under 65, in a trust, in a special needs trust of my own that I have set up as the person with special needs or someone set up on my behalf. And we're going to hold that money in trust, and it's going to take care of me and not interrupt my government benefits. But when I subsequently die, we're first going to have to pay the state back. And that's what a first party special needs trust is going to do. Those are the ones that you hear the most. The thing about a special needs trust I want you to know is that just by way of having a special needs trust means nothing about the beneficiary. It doesn't mean just by putting it together that they have been adjudicated and capacitated. It doesn't mean that someone somewhere thinks that they have a disability. It doesn't like set off any red flag anywhere. And I get that question a lot. So just putting a special needs trust together, all it does is insulate those assets from a benefits program later on if we decide that we need one, if we decide to apply to one, okay, or somebody does on their behalf, right? The other thing about a special needs trust is the way I typically draft them, if it's third party, is we can make a distribution even if we're receiving government benefits. If it would be better, like the family I mentioned before that has lots and lots of money, we're putting a special needs trust together for him, just in case we ever need a program or we need some help. But if we don't, the trustee can make a distribution to him. And if he's already receiving benefits, they can give him that money, even if it's going to kick him off his benefits, if that's ultimately what's better for him in the discretion of the trustee. So those are what the special needs trusts look like. The other one to think about is a pooled trust, and that's where we have another entity managing it. It's pooled together. In Texas, the popular one is the Arc of Texas, but they will manage all of that money so that it grows better than it would by itself. That's what you see on the trust side. I'm sure there's plenty of questions about the trust too, but then the last thing I would just say to you is that on the estate planning side, your typical wills and the powers of attorney we've already talked about. The able accounts are a huge benefit. An able account Allison can talk to you about all day, but that's a huge benefit. You can only have one in the country, and you have the opportunity to make distributions for in-kind support and maintenance and not interrupt your benefits. That's a really, really special thing. If you're getting a special needs trust drafted, tell your lawyer to give that special needs trust the authority to give money to an able account. That's super helpful. It's relatively new in the law for folks, so that's something that they don't always think about. And then a guardianship is whenever we haven't done this planning, or we have somebody who never was able to do any planning, right? And we know they're going to have a disability. We go to the court and we say, I, as the mother usually or whatever, want to be the guardian for my person with a special need. And we need a doctor's letter to get it started. You have to do training. It's relatively involved to get it set up. And then you're reporting back to the court every year. And so my only comment to you would be to take really good care to make sure that's what you need before you get into it, because not every person with special needs a guardianship. And that is all.
Emily, I just want to say that we have full presentations on the on in the weeds on the first party and the third party special needs trust. Special note that child support post age 18 should go to a first party special needs trust to preserve benefits like SSI. And we also have full presentations on guardianship, and we'd like to invite you back to talk and take a deeper dive into guardianship. And you know, you kind of hit on this in the beginning. I mean, there's obviously lesser restrictive options, the supported decision-making agreement, the power of attorney, some of these other releases that you talked about. I always just like to encourage people because I think people feel intimidated with the idea of guardianship. They feel bad about taking rights away, or maybe they have a kid that's violent and they're afraid that they're going to affect their own life if their kid does something wrong. And I just like to encourage people to meet with a professional because Emily, you sit down with people, you meet with their loved one, you meet with them, and you go through their options with them and lead them in the direction that might makes the most sense, the least restrictive and most appropriate. And I just like to encourage people that they don't have to know everything that they need when they come and sit down for a consultation. It's just kind of learning what your options are and then going from there. But the guardianship process could be started as early as 6 months prior to them turning 18, so it could be completed close to their 18th birthday. Is that correct?
That is correct. Yeah, they'll let you file it that early, but they won't grant it until they turn 18, of course.
Gotcha. Well, Emily, I know that we're out of time for today. You've had a lot of great information. We had a lot of great questions. This is your contact information where people can schedule a consultation. And from a perspective of handling the legal documents and the estate planning things, you do those things. You also help with guardianship as well. And are there any particular counties that you work, or do you work the whole state of Texas, or how does that work for you?
Thank you. That's a good question. Yeah, I practice primarily in Harris County, Montgomery County, Galveston County, Fort Bend, but we are all over. It would just depend on the case and whether you want to pay us to, drive to the place if we need to be in person. But we can work anywhere in Texas, and if we can't, we're members of the National Academy of Elder Law Attorneys, and so we can usually find you an attorney that does special needs work just about anywhere in the state through that group.
Awesome. Well, everybody's going to get a copy of today's slides and a link to the recording. They'll have a link for our upcoming webinars that you can register for. We always offer free personalized consultations. This QR code, you're going to get that as well. That'll take you to a calendar where if you had additional questions that you didn't get answered, that you can get scheduled with us. So reach out to Emily and her team at Rapp and Croc. We stand ready to help you. And again, whether you work with us or you work with somebody else, that's okay, but work with a professional. And I always just say that this is not a do-it-yourself project. There's a lot of things that we can do it ourselves, and we can download things and things like that, but we don't want to find out in the time of crisis that it was a mistake, or it wasn't right, it wasn't what we thought it was. So it is very, very important that way. Thanks everybody for attending today. It's certainly been our pleasure. Check your email, check your spam. Later today you'll get an email with a copy of the slides and a link to the recording. So, and all of our past recordings will live on the Consolidated Planning Group YouTube channel. There's over 500 webinars out there on planning for special needs. So if you can think of a topic, or if you heard something today and you want to go deeper, go out there and find the webinar on that topic, and you'll be able to get the information that you need. So thanks so much, everyone. It's certainly been a pleasure. Thank you, Emily, and we'll look forward to partnering with you again soon.
Thank you, Allison.
Bye now.